Justice Sotomayor?
This would be the first time in the court's history, correct, that it would say that a business open to the public, as this petitioner has said it is, that it's open, a commercial business open to the public, serving the public, that it could refuse to serve a customer based on race, sex, religion, or sexual orientation, correct?
Yes.
Okay. Justice Gorsuch?
Good morning, Mr. Olson.
Is it still morning?
Just barely. It must not feel like it standing where you are.
I'm here all day, Justice.
It's good to see you. We've had some discussion about whether websites are speech or whether they're a service off the shelf. And I, like a lot of my colleagues, don't profess to know much about this. But I do know that there are some stipulations that you made in paragraphs 81, 82, 83, which say that this is customized, personalized, an expressive activity in each and every circumstance. What do we do about that from your perspective? Don't we have to take that as given?
Yes, but it doesn't change the analysis, I think.
Why not? Because I do see a thing very different if I put a cake on display, it's been made, it is what it is, or a website that you can then go customize yourself, and another thing to commission an expressive activity, and to require somebody to create an expression. Those are two different things, analytically in our law. So help me out.
Well, I think along with the stipulations, we need to look at the specific relief that the company seeks.
But those are the stipulations.
No, they are the stipulations. Yeah. And the specific relief that the company seeks is the ability to turn away every single same-sex customer.
Well, they can ask for what they want. What they get might be another thing, Mr. Olson. But how we analyze the case depends upon those stipulations.
Of course it does.
Okay. Okay. And then separately, I was intrigued by your answer before my friends at the 10th Circuit about freelance writers and people like that, and the notion that Colorado could compel, for example, an individual to write a speech or a press release on behalf of, say, a religious entity with whom he or she disagrees. Does every press release writer, freelance writer, have to write a press release for the Church of Scientology, say, even though the beliefs of that institution may be inimical to that person?
Not at all, and I admit I don't have firmly in mind the exact contours of my answer a couple years ago to the 10th Circuit, but I will tell you what Colorado law says, which is a freelance writer may or may not be a public accommodation.
Well, let's assume they are,
okay.
Under your definition, pretty broad, very different than the historical understanding of public accommodation, but we've gone over that.
So assuming away that hard part of the question, getting to what limitations, all that Colorado law requires is that if you choose to offer a service to someone, you need to offer that service to someone else. I
offer to write press releases for anyone. It's not a who, but it is a what. And the what is I won't write a press release that expresses religious views or that I disagree with.
Well, I think certainly a freelance writer who is a public accommodation could say, I don't write press releases that express religious views, full stop. I won't write that for anybody. Right, you can...
No, I'm happy to do it generally speaking, but just not ones I disagree with. There are many I would agree with across a wide variety of religious faiths, but I'm not going to do it for some with whom I disagree.
Well, even in that circumstance, what Colorado looks to is the service you actually provide, and you choose the service so long as you could say...
So the answer is yes, Colorado would compel that person.
No, the answer is no.
Okay, why?
Because Colorado could say, you as a speechwriter could say, I write, the religious speeches that I write touch on a few traditions that I have knowledge of, and I don't write speeches that touch on other knowledges.
Well, no, it's not, you're changing my hypothetical, Mr. Wilson, that I disagree with, that I find offensive to my religious beliefs. That's the hypothetical.
So long as you would sell that to everyone, not based on their religion, but you can define the contours of the product You can choose the contours of the product that you sell, but
I call it speech, but you can call it a product if you want.
we'll call it speech. You can choose the content of what you sell. You just can't
What you
choose
say.
who you sell to.
Okay.
Right. And so you could say, I'm going to focus on these things, and but I need to sell that to everyone, even if the person who wants to buy it is a member of a religious faith that I disagree with.
So
That's fine.
I will write a press release for many faiths and many belief systems that are, but they have to be consistent with mine, and I won't do it if it offends my religious faith. Good to go.
So long as you sell that to everybody.
Yes. Okay.
Yes.
All right. What's different about this case? Because, I'll just finish the question. I'm already ready to answer it. But we have an individual who says she will sell and does sell to everyone, all manner of websites. But she won't sell a website that requires her to express a view about marriage that she finds offensive to her religious beliefs. What's the difference between the two cases? I'm struggling to understand.
The difference is, and again, looking at the specific relief the company seeks, is
Put aside the specific relief the company seeks, because it's up to courts to fashion relief. So that's not going to persuade me. Work on something that might.
the difference is that distinction. The company has chosen to say they want to provide wedding websites generally, and they will not provide
All manner of websites. This individual will provide all manner of websites, just not one that requires her to write something, words on a page, customizable, all the stuff you stipulated to, that celebrate a particular thing that she finds offends her religious beliefs. I'm looking for the distinction between the two cases. One you say is okay, the other one not okay.
because the company, unlike our first example of the speechwriter,
Yeah.
the company here says in no uncertain terms will they ever sell a company, a product or a service to a same-sex couple for
No,
wedding
what they
websites.
say is we will not sell to anyone, a message that I disagree with as a matter of religious faith, just as a speechwriter says, or the press release writer, the freelance writer says, I will not sell to anyone a speech that offends my religious beliefs.
But here they are defining their service by excluding someone based on their,
That's their religious belief.
well, in
You
Colorado.
can't change their religious belief, right?
No, but well,
And you
two-
protect religious beliefs under the statute, right? That is one of the protected characteristics, in theory.
and in practice. If it wasn't in practice, we had heard about it over the past several years, and my friend has pointed to no example where this has been applied.
Mr. Phillips did go through a re-education training program pursuant to Colorado law, did he not, Mr. Olson?
He went through a process that ensured he was familiar with.
It was a re-education program, right?
It was not a re-education program.
What do you
Mr.
call
Forrest.
it?
It was a process to make sure he was familiar with Colorado law.
Someone might be excused for calling that a re-education
I strongly
program.
disagree, Justice Gorsuch.
Thank you, Mr. Olson.